DPH provides this copy of the regulation for the convenience of the public and makes every effort to ensure its accuracy. However, this is an unofficial version of the regulation. The regulation's most recent final publication in the South Carolina State Register presents the official, legal version of the regulation. Section 100. Definitions and license requirements. Definitions. For the purpose of this regulation, the following definitions shall apply. Abuse. Physical abuse or psychological abuse. Physical abuse. The act of intentionally inflicting or allowing to be inflicted physical injury on a resident by an act or failure to act. Physical abuse includes, but is not limited to, slapping, hitting, kicking, biting, choking, pinching, burning, actual or attempted sexual battery. Use of medication outside the standards of reasonable medical practice for the purpose of controlling behavior and unreasonable confinement. Physical abuse also includes the use of a restrictive or physically intrusive procedure to control behavior for the purpose of punishment, except that a therapeutic procedure prescribed by a licensed physician or other legally authorized healthcare professional or that is part of a written ICP by a physician or other legally authorized healthcare professional is not considered physical abuse. Physical abuse does not include altercations or acts of assault between residents. Psychological abuse. The deliberate use of any oral, written, or gestured language or depiction that includes disparaging or derogatory terms to a resident or within the resident's hearing distance, regardless of the resident's age, ability to comprehend, or disability, including threats or harassment or other forms of intimidating behavior causing fear, humiliation, degradation, agitation, confusion, or other forms of serious emotional distress. Activities of daily living, ADL. Those personal functions performed by an individual in the course of a day that include, but are not limited to, walking, bathing, shaving, brushing teeth, combing hair, dressing, eating, getting in or getting out of bed, toileting, ambulating, doing laundry, cleaning room, managing money, shopping, using public transportation, making telephone calls, obtaining appointments, administration of medication, and other similar activities. Administrator. The staff member designated by the licensee to have the authority and responsibility to manage the facility, is in charge of all functions and activities of the facility and is appropriately licensed as a community residential care facility administrator by the South Carolina State Board of Long-Term Health Care Administrators. Adult. A person 18 years of age or older. Airborne Infection Isolation, AI. A room designed to maintain airborne infection isolation, formerly called a negative pressure isolation room. An airborne infection isolation room is a single-occupancy resident care room used to isolate persons with suspected or confirmed infectious tuberculosis, TB, disease. Environmental factors are controlled in airborne infection isolation rooms to minimize the transmission of infectious agents that are usually spread from person to person by droplet nuclei associated with coughing or aerosolization of contaminated fluids. Airborne infection isolation rooms may provide negative pressure in the room so that air flows under the door gap into the room, an airflow rate of 6 to 12 air changes per hour, ACH, and direct exhaust of air from the room to the outside of the building or recirculation of air through a high-efficiency particulate air, HEPA, filter. Alzheimer's Special Care Unit or Program. A facility or area within a facility providing a secure, special program or unit for residents with a diagnosis of probable Alzheimer's disease and/or related dementia to prevent or limit access by a resident outside the designated or separated areas, and that advertises, markets, or otherwise promotes the facility as providing specialized care/services for persons with Alzheimer's disease and/or related dementia or both. Annual. A time period that requires an activity to be performed at least every 12 to 13 months. Assessment. A procedure for determining the nature and extent of the problems and needs of a resident/potential resident to ascertain if the facility can adequately address those problems, meet those needs, and to secure information for use in the development of the individual care plan. Included in the process are an evaluation of the physical, emotional, behavioral, social, spiritual, nutritional, recreational, and, when appropriate, vocational, educational, legal status/needs of a resident/potential resident. Consideration of each resident's needs, strengths, and weaknesses shall be included in the assessment. Authorized healthcare provider. An individual authorized by law and currently licensed in South Carolina to provide specific treatments, care, or services to residents, e.g., advanced practice registered nurse, physician assistant. Blood assay for Mycobacterium tuberculosis, BMT. A general term to refer to in vitro diagnostic tests that assess for the presence of tuberculosis, TB, infection with tuberculosis. This term includes, but is not limited to, IFN gamma release assays, IGRA. Boarding house. A business/entity which provides room and board to an individuals and which does not provide a degree of personal care for more than one individual. Community Residential Care Facility, CRCF. A facility which offers room and board and which, unlike a boarding house, provides/coordinates a degree of personal care for a period of time in excess of 24 consecutive hours for 2 or more persons, 18 years old or older, not related to the licensee within the 3rd degree of consanguinity. It is designed to accommodate residents' changing needs and preferences, maximize residents' dignity, autonomy, privacy, independence, and safety, and encourage family and community involvement. Included in this definition is any facility, other than a hospital, which offers or represents to the public that it offers a beneficial or protected environment specifically for individuals who have mental illness or disabilities. These facilities may be referred to as assisted living, provided they meet the above definition of community residential care facility. Contact investigation. Procedures that occur when a case of infectious TB is identified, including finding persons, contacts, exposed to the case, testing and evaluation of contacts to identify latent TB infection, LTBI, or TB disease, and treatment of these persons as indicated. Controlled substance. A medication or other substance included in Schedule 1, 2, 3, 4, and V of the Federal Controlled Substances Act and the South Carolina Controlled Substances Act. Consultation. A visit by department representatives who will provide information to the licensee with the goal of facilitating compliance with these regulations. Department. The South Carolina Department of Health and Environmental Control, DHEC. Designee. A staff member designated by the administrator to act on his/her behalf. Direct care staff member/direct care volunteer. Those individuals who provide assistance with activities of daily living to residents. Discharge. The point at which residence in a facility is terminated and the facility no longer maintains active responsibility for the care of the resident. Dispensing medication. The transfer or possession of one or more doses of a medication or device by a licensed pharmacist or individual as permitted by law, to the ultimate consumer or his or her agent pursuant to a lawful order of a practitioner in a suitable container appropriately labeled for subsequent administration to or use by a resident. Exploitation. 1. Causing or requiring a resident to engage in an activity or labor that is improper, unlawful, or against the reasonable and rational wishes of a resident. Exploitation does not include requiring a resident to participate in an activity or labor that is a part of a written ICP or prescribed or authorized by the resident's attending physician. 2. An improper, unlawful, or unauthorized use of the funds, assets, property, power of attorney, guardianship, or conservatorship of a resident by an individual for the profit or advantage of that individual or another individual. Or 3. Causing a resident to purchase goods or services for the profit or advantage of the seller or another individual through undue influence, harassment, duress, force, coercion, or swindling by overreaching, cheating, or defrauding the resident through cunning arts or devices that delude the resident and cause him or her to lose money or other property. Facility. A community residential care facility licensed by the department. Health assessment. An evaluation of the health status of a staff member/volunteer by a physician, other authorized healthcare provider, or registered nurse, pursuant to written standing orders and/or protocol approved by a physician's signature. The standing orders/protocol shall be reviewed annually by the physician, with a copy maintained at the facility. Incident. An unusual, unexpected adverse event resulting in harm, injury, or death of staff or residents, accidents, e.g., medication errors, adverse medication reactions, elopement of a resident. Individual Care Plan, ICP. A documented regimen of appropriate care/services or written action plan prepared by the facility for each resident based on residents' needs and preferences, and which is to be implemented for the benefit of the resident. Inspection. A visit by a department representatives for the purpose of determining compliance with this regulation. Investigation. A visit by a department representatives to a licensed or unlicensed entity for the purpose of determining the validity of allegations received by the department relating to this regulation. Latent TB infection, LTBI. Infection with M. tuberculosis. Persons with latent TB infection carry the organism that causes TB but do not have TB disease, are asymptomatic, and are non-infectious. Such persons usually have a positive reaction to the tuberculin skin test and/or positive BNT. Legend drug. A drug when, under federal law, is required, prior to being dispensed or delivered, to be labeled with any of the following statements. Caution. Federal law prohibits dispensing without prescription. RX only or a drug which is required by any applicable federal or state law to be dispensed pursuant only to a prescription drug order or is restricted to use by practitioners only. Any drug products considered to be a public health threat after notice and public hearing as designated by the South Carolina Board of Pharmacy, or any prescribed compounded prescription drug within the meaning of the Pharmacy Act. License. The authorization to operate a facility as defined in this regulation and as evidenced by a current certificate issued by the department to a facility. Licensed nurse. A person to whom the South Carolina Board of Nursing has issued a license as a registered nurse or licensed practical nurse, or an individual licensed as a registered nurse or licensed practical nurse who resides in another state that has been granted multi-state licensing privileges by the South Carolina Board of Nursing may practice nursing in any facility or activity licensed by the department subject to the provisions and conditions as indicated in the Nurse Licensure Compact Act. Licensee. The individual, corporation, organization, or public entity that has received a license to provide care/services at a facility and with whom rests the ultimate responsibility for compliance with this regulation. Local transportation. The maximum travel distance the facility shall undertake, at no cost to the resident, as addressed by the resident written agreement, to secure/provide health care for resident. Local transportation shall be based on a reasonable assessment of the proximity of customary health care resources in the region, e.g., nearest hospitals, physicians, and other health care providers, and appropriate consideration of resident preferences. Medication. A substance that has therapeutic effects, including, but not limited to, legend, non-legend, herbal products, over-the-counter, non-prescription, vitamins and nutritional supplements, etc. Neglect. The failure or omission of a direct care staff member or direct care volunteer to provide the care, goods, or services necessary to maintain the health or safety of a resident, including, but not limited to, food, clothing, medicine, shelter, supervision, and medical services. Failure to provide adequate supervision resulting in harm to residents, including altercations or acts of assault between residents, may constitute neglect. Neglect may be repeated conduct or a single incident that has produced or could result in physical or psychological harm or substantial risk of death. Noncompliance with regulatory standards alone does not constitute neglect. Non-legend drug. A drug which may be sold without a prescription and which is labeled for use by the consumer in accordance with the requirements of the laws of the state and the federal government. Nursing home. A facility with an organized nursing staff to maintain and operate organized facilities and services to accommodate two or more unrelated individuals over a period exceeding 24 hours, which is operated either in connection with a hospital or as a freestanding facility for the express or implied purpose of providing intermediate or skilled care for persons who are not in need of hospital care. Peak hours. Those hours from 7 a.m. to 7 p.m. or as otherwise approved in writing by the department. Personal care. The provision by the staff members/direct care volunteers of the facility of one or more of the following services, as required by the individual care plan or orders by the physician or other authorized healthcare provider or as reasonably requested by the resident, including assisting and/or directing the resident with activities of daily living. Being aware of the resident's general whereabouts, although the resident may travel independently in the community. Monitoring of the activities of the resident while on the premises of the residence to ensure his/her health, safety, and well-being. Personal monies. All monies which are available to the resident for his/her personal use, including family donations. Physical examination. An examination of a resident by a physician or other authorized healthcare provider which addresses those issues identified in Section 1101 of this regulation. Physician. An individual currently licensed to practice medicine by the South Carolina Board of Medical Examiners. Physician assistant. An individual currently licensed as such by the South Carolina Board of Medical Examiners. Private sitter. A private contractor not associated with or employed by the facility with whom the resident or the resident's responsible party contracts to provide sitter or companion services. Quality Improvement Program. The process used by a facility to examine its methods and practices of providing care/services, identify the ways to improve its performance, and take actions that result in higher quality of care/services for the facility's residents. Quarterly. A time period that requires an activity to be performed at least four times a year within intervals ranging from 81 to 99 days. Related/relative. This degree of kinship is considered within the third degree of consanguinity, e.g., a spouse, son, daughter, sister, brother, parent, aunt, uncle, niece, nephew, grandparent, great-grandparent, grandchild, or great-grandchild. Repeat violation. The recurrence of a violation cited under the same section of the regulation within a 36-month period. The time period determinant of repeat violation status is applicable in instances when there are ownership changes. Resident. Any individual, other than staff members/volunteers or owner and their family members, who resides in a facility. Resident room. An area enclosed by 4 ceiling-high walls that can house one or more residents of the facility. Respite care. Short-term care, a period of 6 weeks or less, provided to an individual to relieve the family members or other persons caring for the individual, but for not less than 24 hours. Responsible party. A person who is authorized by law to make decisions on behalf of a resident, to include, but not be limited to, a court-appointed guardian or legal guardian as referred to in the resident's Bill of Rights, or conservator, or health care or other durable power of attorney. Restraint. Any means by which movement of a resident is inhibited, i.e., physical, mechanical, chemical. In addition, devices shall be considered a restraint if a resident is unable to easily release from the device. Revocation of license. An action by the department to cancel or annul a facility license by recalling, withdrawing, or rescinding its authority to operate. Risk assessment. An initial and ongoing evaluation of the risk for transmission of tuberculosis in a particular healthcare setting. To perform a risk assessment, the following factors shall be considered: the community rate of TB, number of TB patients encountered in the setting, and the speed with which patients with TB disease are suspected, isolated, and evaluated. The TB risk assessment determines the types of administrative and environmental controls and respiratory protection needed for a setting. Self-administration. A procedure by which any medication is taken orally, injected, inserted, or topically or otherwise administered by a resident to himself or herself without prompting. The procedure is performed without assistance and includes removing an individual dose from a previously dispensed and labeled container, including a unit dose container, verifying it with the directions on the label, taking it orally, injecting, inserting, or applying topically or otherwise administering the medication. Sponsor. The public agency or individual involved in one or more of the following: protective custody authorized by law, placement, providing ongoing services, or assisting in providing services to a residence consistent with the wishes of the resident or responsible party or specific administrative or court order. Staff member. An adult, to include the administrator, who is a compensated employee of the facility on either a full or part-time basis. Suspension of license. An action by the department requiring a facility to cease operations for a period of time or to require a facility to cease admitting residents until such time as the department rescinds that restriction. Volunteer. An adult who performs tasks at the facility at the direction of the administrator without compensation. References. The following departmental publications are referenced in these regulations. R.61-20 Communicable Diseases. R.61-25 Retail Food Establishments. R.61-51 Public Swimming Pools. R.61-58 State Primary Drinking Water Regulations. R.61-67 Standards for Wastewater Facility Construction. 6. R.61-105 South Carolina Infectious Waste Management Regulations. The following non-departmental publications are referenced within this regulation. Underwriters Laboratories Fire Resistance Directory. Underwriters Laboratories Building Materials List. Occupational Safety and Health Act of 1970, OSHA. Omnibus Adult Protection Act. Alzheimer's Special Care Disclosure Act. Food and Nutrition Board of the National Research Council, National Academy of Sciences. National Sanitation Federation. Guidelines for Preventing the Transmission of Mycobacterium tuberculosis in Healthcare Settings, December 30, 2005. U.S. Pharmacopoeia. The Department shall enforce new laws that may change the above-noted standards and at its discretion adopt revisions to the above-noted references. 103. License Requirements. 2. License. No person, private or public organization, political subdivision, or governmental agency shall establish, operate, maintain, or represent itself, advertise/market as a community residential care facility in South Carolina without first obtaining a license from the department. The facility shall not admit residents prior to the effective date of the license. When it has been determined by the department that room, board, and a degree of personal care to 2 or more adults unrelated to the owner is being provided at a location, and the owner has not been issued a license from the department to provide such care, the owner shall cease operation immediately and ensure the safety, health, and well-being of the occupants. Current/previous violations of the South Carolina Code and/or department regulations may jeopardize the issuance of a license for the facility or the licensing of any other facility, or addition to an existing facility which is owned/operated by the licensee. The facility shall provide only the care/services it is licensed to provide pursuant to the definitions in Sections 101L and 101 LL of this regulation. 1. Compliance. An initial license shall not be issued to a proposed facility that has not been previously and continuously licensed under department regulations until the licensee has demonstrated to the department that the proposed facility is in substantial compliance with the licensing standards. In the event a licensee who already has a facility/activity licensed by the department makes application for another facility or increase in licensed bed capacity, the currently licensed facility/activity shall be in substantial compliance with the applicable standards prior to the department issuing a license to the proposed facility or amended license to the existing facility. A copy of the licensing standards shall be maintained at the facility and accessible to all staff members/volunteers. Facilities shall comply with applicable local, state, and federal laws, codes, and regulations. Compliance with structural standards. Facilities licensed at the time of promulgation of this regulation shall be allowed to continue utilizing the previously licensed structure without res. Licensed bed capacity. No facility that has been authorized to provide a set number of licensed beds, as identified on the face of the license, shall exceed the bed capacity. No facility shall establish new care/services or occupy additional beds or renovated space without first obtaining authorization from the department. Beds for use of staff members/volunteers are not included in the licensed bed capacity number, provided such beds and locations are so identified and used exclusively by staff members/volunteers. 1. Persons received in excess of licensed bed capacity. No facility shall receive for care or services persons in excess of the licensed bed capacity, except in cases of justified emergencies. 1. Exception. In the event that the facility temporarily provides shelter for evacuees who have been displaced due to a disaster, then for the duration of that emergency, provided the health, safety, and well-being of all residents are not compromised, it is permissible to temporarily exceed the licensed capacity for the facility in order to accommodate these individuals. See Section 606. Living quarters for staff members. In addition to residents, only staff members, volunteers, or owners of the facility and members of the owner's immediate family may reside in facilities licensed under this regulation. Resident rooms shall not be utilized by any individuals other than facility residents, nor shall bedrooms of staff members/family members of the owner or the licensee be utilized by residents. Staff members/family members of the owner or licensee/volunteers shall not use resident living rooms, recreational areas, or dining rooms unless they are on duty. Issuance and terms of license. A license is issued by the department and shall be posted in a conspicuous place in a public area within the facility. The issuance of a license does not guarantee adequacy of individual care, services, personal safety, fire safety, or the well-being of any resident or occupant of a facility. A license is not assignable or transferable and is subject to revocation at any time by the department for the licensee's failure to comply with the laws and regulations of the state. A license shall be effective for a specified facility at a specific locations for a specified period following the date of issue as determined by the department. A license shall remain in effect until the department notifies the licensee of a change in that status. Facilities owned by the same entity but which are not located on the same adjoining or contiguous property shall be separately licensed. Roads or local streets, except limited access, e.g., interstate highways, shall not be considered as dividing otherwise adjoining or contiguous property. Facilities owned by the same entity, separate licenses are not required for separate buildings on the same or adjoining grounds where a single level or type of care is provided. Multiple types of facilities on the same premises shall be licensed separately even though owned by the same entity. Facilities may furnish respite care provided compliance with the standards of this regulation are met. Facility name. No proposed facility shall be named nor shall any existing facility have its name changed to the same or similar name as any other facility licensed in South Carolina. The department shall determine if names are similar. If the facility is part of a chain operation, it shall then have the geographic area in which it is located as part of its name. Application. Applicants for a license shall submit to the department a complete and accurate application on a form prescribed and furnished by the department prior to initial licensing and periodically thereafter at intervals determined by the department. The application includes both the applicant's oath assuring that the contents of the application are accurate/true and that the applicant will comply with this regulation. The application shall be signed by the owners if an individual or partnership, in the case of a corporation, by 2 of its officers, or in the case of a governmental unit, by the head of the governmental department having jurisdiction. The application shall set forth the full name and address of the facility for which the license is sought and of the owner in the event his/her address is different from that of the facility, the names of the persons in control of the facility. The department may require additional information, including affirmative evidence of the applicant's ability to comply with these regulations. Corporations or limited partnerships, limited liability companies, or any other organized business entity must be registered with the South Carolina Office of the Secretary of State if required to do so by South Carolina state law. Licensing fees. The annual license fee shall be $10 per licensed bed or $75 whichever is greater. Such fee shall be made payable by check or credit card to the department and is not refundable. Fees for additional beds shall be prorated based upon the remaining months of the licensure year. If the application is denied or withdrawn, a portion of the fee may be refunded based upon the remaining months of the licensure year, or $75 whichever is lesser. Late fee. Failure to submit a renewal application or fee 30 days or more after the license expiration date may result in a late fee of $75 or 25% of the licensing fee amount, whichever is greater, in addition to the licensing fee. Continual failure to submit completed and accurate renewal applications and/or fees by the time period specified by the department may result in an enforcement action. License renewal. For a license to be renewed, applicants shall file an application with the department, pay a license fee, and shall not be undergoing enforcement actions by the department. If the license renewal is delayed due to enforcement actions, the renewal license shall be issued only when the matter has been resolved satisfactorily by the department, or when the adjudicatory process is completed, whichever is applicable. Change of license. A facility shall request issuance of an amended license by application to the department prior to any of the following circumstances. Change of ownership. Change of licensed bed capacity. Change of facility location from one geographic site to another. Changes in facility name or address, as notified by the post office, shall be accomplished by application or by letter from the licensee. Exceptions to licensing standards. The department has the authority to make exceptions to these standards where the department determines the health, safety, and well-being of the residents are not compromised, and provided the standard is not specifically required by statute. Section 200. Enforcing regulations. General. The department shall utilize inspections, investigations, consultations, and other pertinent documentation regarding a proposed or licensed facility in order to enforce this regulation. Inspections/investigations. Inspections by the department shall be conducted prior to initial licensing of a facility and subsequent inspections conducted as deemed appropriate by the department. 1. All facilities are subject to inspection/investigation at any time without prior notice by individuals authorized by South Carolina Code of Laws. When staff members/volunteers/residents are absent, the facility shall provide information to those seeking legitimate access to the facility, including visitors, as to the expected return of staff members/volunteers/residents. 1. Individuals authorized by South Carolina law shall be allowed to enter the facility for the purpose of inspection and/or investigation and granted access to all properties and areas, objects, and records in a timely manner, and have the authority to require the facility to make photocopies of those documents required in the course of inspections or investigations. Photocopies shall be used only for purposes of enforcement of regulations, and confidentiality shall be maintained except to verify the identity of individuals in enforcement action proceedings. Physical area of inspections shall be determined by the extent to which there is potential impact/effect upon residents as determined by the inspector, e.g., flammable liquids unsecured in a staff member's bedroom, attic, or basement. 1. When there is non-compliance with the licensing standards, the facility shall submit an acceptable written plan of correction to the department that shall be signed by the administrator and returned by the date specified on the report of inspection/investigation. The written plan of correction shall describe 2. The actions taken to correct each cited deficiency. The actions taken to prevent recurrences, actual and similar. The actual or expected completion dates of those actions. Reports of inspections or investigations conducted by the department, including the facility response, shall be provided to the public upon written request with the redaction of the names of those individuals in the report as provided by 1976 Code Sections 44-7-310 and 44-7-315. In accordance with 1976 Code Section 44-7-270, the department may charge a fee for plan inspections, construction inspections, and licensing inspections. Consultations. Consultations shall be provided by the department as requested by the facility or as deemed appropriate by the department. Section 300. Enforcement actions. General. When the department determines that a facility is in violation of any statutory provision, rule, or regulation relating to the operation or maintenance of such facility, the department, upon proper notice to the licensee, may impose a monetary penalty, deny, suspend, or revoke licenses. Violation classifications. Violations of standards in this regulation are classified as follows. Class 1 violations are those that the department determines to present an imminent danger to the health, safety, or well-being of the persons in the facility or a substantial probability that death or serious physical harm could result therefrom. A physical condition or one or more practices, means, methods, or operations in use in a facility may constitute such a violation. The condition or practice constituting a Class 1 violation shall be abated or eliminated immediately unless a fixed period of time, as stipulated by the department, is required for correction. Each day such violation exists after expiration of the time established by the department shall be considered a subsequent violation. Class 2 violations are those, other than Class 1 violations, that the department determines to have a negative impact on the health, safety, or well-being of persons in the facility. The citation of a Class 2 violation shall specify the time within which the violation is required to be corrected. Each day such violation exists after expiration of this time shall be considered a subsequent violation. Class 3 violations are those that are not classified as Class 1 or 2 in these regulations or those that are against the best practices as interpreted by the department. The citation of a Class 3 violation shall specify the time within which the violation is required to be corrected. Each day such violation exists after expiration of this time shall be considered a subsequent violation. The notations 1 or 2 placed within sections of this regulation indicate those standards are considered Class 1 or 2 violations if they are not met, respectively. Failure to meet standards not so annotated are considered Class 3 violations. In determining an enforcement action, the department shall consider the following factors: specific conditions and their impact or potential impact on health, safety, or well-being of the residents, including, but not limited to, deficiencies in medication management, such as evidence that residents are not routinely receiving their prescribed medications, serious wastewater problems, such as toilets not operating or open sewage covering the grounds, housekeeping/maintenance/fire and life safety related problems that pose a health threat to the residents, power/water/gas or other utility and or service outages, residents exposed to air temperature extremes that jeopardize their health, unsafe condition of the building/structure, such as a roof in danger of collapse, indictment of an administrator for malfeasance or a felony, which by its nature, such as drug dealing, indicates a threat to the residents, direct evidence of abuse, neglect, or exploitation, lack of food or evidence that the residents are not being fed properly, no staff available at the facility with residents present, unsafe procedures/treatment being practiced by staff. 1. Repeated failure of the licensee/facility to pay assessed charges for utilities and/or services, resulting in repeated or ongoing threats to terminate the contracted utilities and/or services. 2. Efforts by the facility to correct cited violations. Overall conditions of the facility. History of compliance, and any other pertinent conditions that may be applicable to current statutes and regulations. When imposing a monetary penalty, the Department may invoke 1976 Code Section 44-7-320(c) to determine the dollar amount or may utilize the following schedule. Frequency of violation of standard within a 36-month period. Section 400. Policies and Procedures. For 01, General. 2. Written policies and procedures addressing each section of this regulation regarding resident care, rights, and the operation of the facility shall be developed and implemented, and revised as required in order to accurately reflect actual facility operation. The policies and procedures shall address the provision of any special care offered by the facility, which would include how the facility shall meet the specialized needs of the affected residents, such as Alzheimer's disease and/or related dementia, physically/developmentally disabled, in accordance with any laws which pertain to that service offered, e.g., Alzheimer's Special Care Disclosure Act. Facilities shall establish a time period for review of all policies and procedures, and such reviews shall be documented. These policies and procedures shall be accessible and available to staff at all times, and shall be available to residents and/or their responsible parties upon their requests for inspection. Section 500. Staff/training. General. 2. Before being employed or contracted as a staff member/direct care volunteer by a licensed community residential care facility, a person shall undergo a criminal background check pursuant to 1976 Code Section 44-7-2910. Staff members/direct care volunteers/private sitters of the facility shall not have a prior conviction or pled no contest, nolo contendere, to abuse, neglect, or exploitation of a child or a vulnerable adult as defined in 1976 Code Section 43-35-10, etc. Staff members/volunteers shall be provided the necessary training to perform the duties for which they are responsible in an effective manner. No supervision/care/services shall be provided to individuals who are not residents of the facility other than children of owners of the facility who are residing in the facility. Minimum staffing requirements shall be applied in instances where children of owners reside in the facility, i.e., children of owners shall be considered as residents in the staff/resident ratio. Staff members/direct care volunteers shall have at least the following qualifications. Capable of rendering care/services to residents. Sufficient education to be able to perform their duties and to speak, read, and write English. Demonstrate a working knowledge of applicable regulations. There shall be accurate and current information maintained regarding all staff members/volunteers of the facility, to include at least address, phone number, and personal/work/training background. All staff members/direct care volunteers shall be assigned certain duties and responsibilities which shall be in writing and in accordance with the individual's capability. When a facility engages a source other than the facility to provide services normally provided by the facility, e.g., staffing, training, recreation, food service, professional consultant, maintenance, transportation, there shall be a written agreement with the source that describes how and when the services are to be provided, the exact services to be provided, and that these services are to be provided by qualified individuals. The source shall comply with this regulation in regard to resident care, services, and rights. Administrator. 2. The facility administrator shall be licensed as a CRCF administrator in accordance with 1976 Code Section 44-7-260. The administrator shall exercise judgment that reflects that she is capable of meeting the responsibilities involved in operating a facility to ensure that it is in compliance with these regulations, and shall demonstrate adequate knowledge of these regulations. A staff member shall be designated in writing to act in the absence of the administrator, e.g., a listing of the lines of authority by position title, including the names of the persons filling these positions. Staff. 1. There shall be a staff member actively on duty and present in the facility at all times that the facility is occupied by residents and to whom the residents can immediately report injuries, symptoms of illness, or emergencies. This staff member shall recognize and report significant changes in the physical or mental condition of each resident and shall ensure that appropriate action is taken. The number and qualifications of staff members/direct care volunteers shall be determined by the number and condition of the residents. There shall be sufficient staff members/direct care volunteers to provide supervision, direct care, and basic services for all residents. The minimum number of staff members/direct care volunteers that shall be maintained in all facilities. In each building, there shall be at least one staff member/direct care volunteer for each 8 residents or fraction thereof on duty during all periods of peak hours. In each building during non-peak hours, there shall be at least one staff member/volunteer on duty for each 30 residents or fraction thereof. A staff member/volunteer shall be awake and dressed at all times. Staff member S/volunteer S shall be able to appropriately respond to resident needs during non-peak hours. In facilities that are licensed for more than 10 beds and the facility is of multi-floor design, there shall be a staff member available on each floor at all times residents are present on that floor. The facility shall maintain documentation to ensure the facility meets sections 503, B.1 and 503, B.2. In-service training. 1. Documentation of all in-service training shall be signed and dated by both the individual providing the training and the individual receiving the training. The following training shall be provided by appropriate resources, e.g., licensed/registered/certified persons, books, electronic media, etc. To all staff members/direct care volunteers and private sitters in the context of their job duties and responsibilities prior to resident contact and at a frequency determined by the facility, but at least annually unless otherwise specified by certificate, e.g., cardiopulmonary resuscitation, CPR. Basic first aid to include emergency procedures as well as procedures to manage/care for minor accidents or injuries. Procedures for checking and recording vital signs, for designated staff members only. Management/care of persons with contagious and/or communicable disease, e.g., hepatitis, tuberculosis, HIV infection. Medication management including storage, administration, receiving orders, securing medications, interactions, and adverse reactions. Depending on the type of residence, care of persons specific to the physical/mental condition being cared for in the facility, e.g., dementia, cognitive disability, mental illness, or aggressive, violent, and/or inappropriate behavioral symptoms, etc., to include communication techniques, cueing and mirroring, understanding and coping with behaviors, safety, activities, etc. Use of restraint techniques. OSHA standards regarding bloodborne pathogens. Cardiopulmonary resuscitation for designated staff members/direct care volunteers to ensure that there is a certified staff member/direct care volunteer present whenever residents are in the facility. Confidentiality of resident information and records. Bill of Rights for Long-Term Care Facilities per 1976 Code Section 44-81-10 DHEC. Fire response training within 24 hours of their first day on the job in the facility, see Section 1503. Emergency procedures/disaster preparedness within 24 hours of their first day on the job in the facility, see Section 1400, and activity training for the designated staff only. Job orientation. All new staff members/direct care volunteers shall have documented orientation to the organization and environment of the facility, specific duties and responsibilities of staff members/direct care volunteers, and residents' needs within 24 hours of their first day on the job in the facility. Health status. 1. All staff members/direct care volunteers who have contact with residents, including food service staff members/direct care volunteers, shall have a health assessment within 12 months prior to initial resident contact. The health assessment shall include tuberculin skin testing as described in Section 1702. If a staff member/direct care volunteer is working at multiple facilities operated by the same licensee, copies of records for tuberculin skin testing and the pre-employment health assessment shall be accessible at each facility. For any other staff member/direct care volunteer, a copy of the tuberculin skin testing shall be acceptable provided the test had been completed within 3 months prior to resident contact. Private sitters. 2. Unless the written agreement, see Section 901A, between a resident and the facility prohibits the use of private sitters, the facility shall establish a formalized private sitter program directed by a facility staff member so that residents or their responsible party may contract for sitter services. The facility shall assure that private sitters have been chosen in accordance with the resident's Bill of Rights. Facilities allowing the use of private sitters shall establish written policies and procedures for private sitters. Prior to resident contact, the private sitter shall have documented orientation to the organization and environment of the facility. Orientation to the facility shall consist, at least, of the following: residents' rights, confidentiality, disaster preparedness, emergency response procedures, safety procedures and precautions, and infection control. There shall be accurate current information maintained regarding private sitters including name, address, and telephone number, documentation of orientation to the facility, including residents' rights, regulation compliance, policies and procedures, training, and duties. Date of initial resident contact may be maintained by the facility, if applicable. The facility shall maintain the following documentation regarding private sitters: a health assessment, in accordance with Section 505A, within 12 months prior to initial resident contact or his or her first day working as a private sitter. A criminal record check, see Section 501B, completed prior to working as a private sitter. Determination of TB status, see Section 1702D, prior to initial resident contact or his or her first day working as a private sitter. Private sitters shall not be included in the minimum staffing requirements of Section 503B. Private sitters shall sign in and sign out with facility staff upon entering or leaving the facility. Private sitters shall display identification in accordance with facility policies and procedures that is visible at all times while on duty. Section 600. Reporting. Accidents and/or incidents. A facility shall maintain a record of each accident and/or incident, including usage of mechanical/physical restraints involving residents, staff members, or volunteers occurring in the facility or on the facility grounds. A facility's record of each accident and/or incident shall be documented, reviewed, investigated, and, if necessary, evaluated in accordance with facility policies and procedures and retained by the facility for 6 years after the resident stops receiving services. A facility shall report every serious accident and/or incident that results in resident's death or significant loss of function or damage to a body structure, not related to the natural course of a resident's illness or underlying condition or normal course of treatment, and resulting from an accident and/or incident occurring to a resident within the facility or on the facility grounds. Serious accidents and/or incidents requiring reporting include, but are not limited to: crimes against resident, confirmed or suspected cases of abuse, neglect, or exploitation, medication error with adverse reaction, hospitalization as a result of the accident and/or incident, severe hematoma, laceration, or burn requiring medical attention or hospitalization, fracture of bone or joint, severe injury involving use of restraints, attempted suicide, or fire. A facility shall immediately report every serious accident and/or incident to the attending physician, next of kin or responsible party, and the department via telephone, email, or facsimile within 24 hours of the serious accident and/or incident. A facility shall submit a written report of its investigation of every serious accident and/or incident to the department within 5 days of the serious accident and/or incident. A facility's written report to the department shall provide at a minimum: facility name, license number, type of accident and/or incident, date accident and/or incident occurred, number of residents directly injured or affected, resident record number or last four digits of Social Security number, resident age and sex, number of staff directly injured or affected, number of visitors directly injured or affected, names of witnesses, identified cause of accident and/or incident, internal investigation results if cause unknown, and brief description of the accident and/or incident, including the location of occurrence and treatment of injuries. A facility shall retain a report of every serious accident and/or incident with all of the information provided to the department and the names, injuries, and treatments associated with each resident, staff, and/or visitor involved. A facility shall retain all serious accident and/or incident records for 6 years after the resident stops receiving services. The administrator or his or her designee shall report every incident involving a resident that leaves the premises for more than 24 hours without notice to staff members of intent to leave to local law enforcement, the resident's responsible party, and the department. The administrator or his or her designee shall immediately notify local law enforcement and the responsible party by telephone when a cognitively impaired resident leaves the premises for any amount of time without notice to staff members. The administrator or his or her designee shall report changes in a resident's condition to the extent that serious health concerns and/or injuries, e.g., fracture, behavioral changes, or heart attack, are evident, to the attending physician and the responsible party immediately, not to exceed 24 hours, consistent with the severity or urgency of the condition in accordance with facility policies and procedures. 1. The administrator or his or her designee shall report abuse and suspected abuse, neglect, or exploitation of residents to the South Carolina Long-Term Care Ombudsman Program in accordance with 1976 Code Section 43-35-25. Fire/disasters 2. The administrator or his or her designee shall notify the department via telephone or email of any fire in the facility and submit to the department a complete written report, including fire department reports, if any, within 72 hours of the occurrence of the fire. The administrator or his or her designee shall report any natural disaster or fire requiring displacement of the residents or jeopardizing or potentially jeopardizing the safety of the residents to the department via telephone or email immediately, with a complete written report including the fire department or other reporting authority, as applicable, submitted within 72 hours. Communicable diseases and animal bites. 1. All cases of diseases and animal bites which are required to be reported to the appropriate county health department shall be accomplished in accordance with our .61-20. Administrator change. The licensee shall notify the department via telephone or email within 72 hours of any change in administrator status. The licensee shall provide the department in writing within 10 days the name of the newly appointed administrator, the effective date of the appointment, copy of the administrator's license, and the hours each day the individual will be working as the administrator of the facility. Accounting of controlled substances. 2. Any facility registered with the Department's Bureau of Drug Control and the United States Drug Enforcement Agency shall report any theft or loss of controlled substances to local law enforcement and to the Department's Bureau of Drug Control upon discovery of the loss/theft. Emergency placement notification. In instances where evacuees have been relocated, the department shall be notified by the relocating facility in writing no later than the following workday, the name of the individuals relocated and the name, address and phone number of the sheltering facility, IS, to which the residents have been relocated. Facility closure. Prior to the permanent closure of a facility, the licensee shall notify the department in writing of the intent to close and the effective closure date. Within 10 days of the closure, the facility shall notify the department of the provisions for the maintenance of the records, the identification of those residents displaced, the relocated site, and the dates and amounts of resident refunds. On the date of closure, the license shall be returned to the department. In instances where a facility temporarily closes, the licensee shall notify the department in writing within 15 days prior to temporary closure. In the event of temporary closure due to an emergency, the facility shall notify the department within 24 hours of the closure via telephone, email, or facsimile. At a minimum, this notification shall include, but not be limited to, the reason for the temporary closure, the location where the residents have been / will be transferred, the manner in which the records are being stored, and the anticipated date for reopening. The department shall consider, upon appropriate review, the necessity of inspecting and determining the applicability of current construction standards of the facility prior to its reopening. If the facility is closed for a period longer than 1 year and there is a desire to reopen, the facility shall reapply to the Department for licensure and shall be subject to all licensing requirements at the time of that application, including construction-related requirements for a new facility. Zero census. In instances when there have been no residents in a facility for any reason for a period of 90 days or more, the facility shall notify the department in writing that there have been no admissions, no later than the 100th day following the date of departure of the last active resident. At the time of that notification, the department shall consider, upon appropriate review of the situation, the necessity of inspecting the facility prior to any new and/or readmissions to the facility. The facility shall still submit an application and pay the licensing fee to keep the license active, even though the facility is at zero census or temporarily closed. If the facility has no residents for a period longer than 1 year, and there is a desire to admit a resident, the facility shall reapply to the Department for licensure and shall be subject to all licensing requirements at the time of that application, including construction-related requirements for a new facility. Section 700. Resident Records. Content. 2. The facility shall initiate and maintain on-site an organized record for each resident. The record shall contain sufficient documented information to identify the resident and the agency and/or person responsible for each resident, support the diagnosis, secure the appropriate care/services as needed, justify the care/services provided to include the course of action taken and results, the symptoms or other indications of sickness or injury, changes in physical/mental condition, the response/reaction to care, medication, and diet provided, and promote continuity of care among providers consistent with acceptable standards of practice. All entries shall be written legibly in ink, typed or electronic media, and signed and dated. Specific entries/documentation shall include at a minimum consultations by physicians or other authorized healthcare providers, orders and recommendations for all medication, care, services, procedures, and diet from physicians or other authorized healthcare providers, which shall be completed prior to or at the time of admission and subsequently as warranted. Verbal orders received shall be documented and include the date, time of receipt of the order, description of the order, and identification of the individual receiving the order. Care/services provided, e.g., hospice, home health. Medications administered and procedures followed if an error is made. Special procedures and preventive measures performed. Notes of observation. In instances that involve significant changes in a resident's medical condition and or the occurrence of a serious incident, notes of observation shall be documented at least daily until the condition is stabilized and or the incident is resolved. In all other instances, notes of observation for residents shall be documented at least monthly. Time, circumstances, and condition of discharge, transfer, or death. Provisions for routine and emergency medical care to include the name and telephone number of the resident's physician, plan for payment, and plan for securing medications. Special information, e.g., do not resuscitate orders, allergies, power of attorney, responsible party, etc. Photograph of resident. Resident photographs shall be at a minimum 2½ inches by 3½ inches, 2½ by 3½ inches, in size, dated, and no more than 24 months old unless significant changes in appearance have occurred necessitating a more recent photograph. Assessment 2. Written assessment of the resident in accordance with Section 101. H shall be conducted by a direct care staff member as evidenced by his or her signature and date within a time period determined by the facility, but no later than 72 hours after admission. Individual care plan. 2. Using the written assessment, the facility shall develop within 7 days of admission an ICP with participation of the resident, administrator, or designee, and or the sponsor or responsible party when appropriate, as evidenced by their signatures and date. The ICP shall be reviewed and or revised as changes in resident needs occur, but not less than semi-annually with the resident, administrator, or designee, and or the sponsor or responsible party as evidenced by their signatures and date. The ICP shall describe the needs of the resident, including the activities of daily living for which the resident requires assistance, i.e., what assistance, how much, who will provide the assistance, how often and when. Requirements and arrangements for visits by or to physicians or other authorized healthcare providers. Advance directives/healthcare power of attorney as applicable. Recreational and social activities which are suitable, desirable, and important to the well-being of the resident. Nutritional needs. The ICP shall delineate the responsibilities of the sponsor and of the facility in meeting the needs of the resident, including provisions for the sponsor to monitor the care and the effectiveness of the facility in meeting those needs. Included shall be specific goal-related objectives based on the needs of the resident as identified during the assessment phase, including adjunct support service needs, other special needs, and the methods for achieving objectives and meeting needs in measurable terms with expected achievement dates. Record maintenance. The licensee shall provide accommodations, space, supplies, and equipment adequate for the protection and storage of resident records. When a resident is transferred from one facility to another, a transfer summary to include at a minimum copies of the most recent physical examination, the two-step tuberculosis test, the ICP and medication administration record, MAR, shall be forwarded to the receiving facility at the time of transfer or immediately after the transfer if the transfer is of an emergency nature. The transfer summary shall include the date sent and the signature of the transferring facility staff member. 1. The resident record is confidential and shall be made available only to individuals authorized by the facility and or the South Carolina Code of Laws. 2. Records generated by organizations/individuals contracted by the facility for care/services shall be maintained by the facility that has admitted the resident. The facility shall determine the medium in which information is stored. Upon discharge of a resident, the record shall be completed within 30 days and filed in an inactive/closed file maintained by the licensee. Prior to the closing of a facility for any reason, the licensee shall arrange for preservation of records to ensure compliance with these regulations. The licensee shall notify the department in writing describing these arrangements and the location of the records. Records of residence shall be maintained for at least six years following the discharge of the resident. Other regulation-required documents, e.g., fire drills, activity schedules, etc., shall be retained at least 12 months or since the last Department General inspection, whichever is the longer period. Records of current residents are the property of the facility and shall be maintained at the facility and shall not be removed without court order. Exception: when a resident moves from one licensed facility to another within the same provider network, same licensee, the original record may follow the resident. The sending facility shall maintain documentation of the resident's transfer/discharge date and identification information. In the event of change of ownership, all active resident records or copies of active resident records shall be transferred to the new owners. Section 800. Admission/retention. 801. General. 1. Individuals seeking admission shall be identified as appropriate for the level of care, services, or assistance offered. The facility shall establish admission criteria that are consistently applied and comply with local, state, and federal laws and regulations. The facility shall admit and retain only those persons appropriate for placement in a CRCF in compliance with the standards of this regulation. The facility shall not admit or retain any of the following persons in compliance with the standards of this regulation. Any person who is likely to endanger himself/herself or others as determined by a physician or other authorized healthcare provider. Any person other than an adult. 2. Any person needing hospitalization or nursing home care. Any person needing daily skilled monitoring/observation due to an unstable or complex medical condition, e.g., brittle diabetes, dialysis patients with complications such as infections in the blood. Any person needing medications that require frequent dosage adjustment, regulation, and/or monitoring, e.g., diabetics receiving sliding scale insulin. Any person needing intravenous medications or fluids, regular intramuscular and subcutaneous injections by staff or by responsible party. This does not include injections administered on a part-time or intermittent basis by non-staff licensed nurses. Routine injections of insulin scheduled daily or less frequently are permitted. Any person needing care of urinary catheter that cannot be managed independently by the resident. Any person needing treatment of stage 2, 3 or 4 decubitus ulcers or multiple pressure sores or other widespread skin disorder. Important considerations include signs of infection, full thickness tissue loss, or requirement of sterile technique. Any person needing nasogastric tube feeding or having to be fed by a syringe or straw due to difficulties in swallowing. Gastrostomy tube feedings that cannot be managed independently by the resident. Any person needing suctioning of the nose and/or mouth. Any person needing tracheostomy or sterile care of the tracheostomy that cannot be managed independently by the resident, or any person receiving oxygen for the first time, which requires adjustment and evaluation of oxygen concentration. The facility shall not retain any of the following persons in compliance with the standards of this regulation. Any person who has a serious aggressive, violent, or socially inappropriate behavioral symptoms which cannot be controlled or improved in the facility. Any person who has a dependency in all activities of daily living for more than 14 consecutive days, e.g., bedridden, incapable of locomotion, unable to transfer, totally incontinent of urinary and/or bowel function, must be totally bathed and dressed and toilet and needs extensive assistance to eat. The facility shall develop a plan for transfer on the 15th day of total dependency if the resident is not improving. Any person needing the continuous daily attention of a licensed nurse, e.g. care of a urinary catheter that cannot be managed independently, treatment of stage 2, 3, or 4 decubitus ulcers. Nursing care may be furnished to residents in need of short-term intermittent nursing care, no more than 14 consecutive days, while convalescing from illness or injury, provided the nursing services, e.g., the utilization of a home health nurse for sterile dressing changes or for observation related to a surgical site, are furnished by a licensed nurse facility staff member or a home health nurse. Residents whose condition changes to a degree that nursing home care, the daily attention of a nurse, or hospitalization may be required, or have a contagious disease, shall be examined by a physician or other authorized healthcare provider regarding the possible necessity for transfer to a facility where the resident's eligibility for admission is appropriate. When the provision of care/services in the facility, combined with other appropriately licensed services in accordance with facility policy, e.g., hospice, home health, as may be ordered by a physician or other authorized healthcare provider, does not meet the needs of the resident, or if any resident becomes in need of continuous medical or nursing supervision, or if the facility does not have the capability to provide necessary care/services, the resident shall be transferred within 30 days to a location which shall meet those needs. The administrator shall coordinate this transfer with the resident, next of kin/responsible party, and sponsor. Section 900. Resident care/services. General. Prior to admission, there shall be a written agreement between the resident and or her responsible party and the facility. The agreement shall be revised upon any changes and shall include at least the following: an explanation of the specific care, services, and or equipment provided by the facility, e.g., administration of medication, provision of special diet as necessary, assistance with bathing, toileting, feeding, dressing, and mobility. Disclosure of fees for all care, services, and or equipment provided. Advance notice requirements of not less than 30 days to change fee amount for care, services, and or equipment. Refund policy to include when monies are to be forwarded to resident upon discharge/transfer/relocation. The date a resident is to receive her personal needs allowance. The amount a resident receives for her personal needs allowance. Transportation policy. Discharge/transfer provisions to include the conditions under which the resident may be discharged and the agreement terminated, and the disposition of personal belongings. Documentation of the explanation of the resident's Bill of Rights and the grievance procedure. 2. The facility shall coordinate with residents to provide care, including diet, services, i.e., routine and emergency medical care, podiatry care, dental care, counseling, and medications, as ordered by a physician or other authorized healthcare provider. Such care shall be provided and coordinated among those responsible during the process of providing such care/services and modified as warranted based upon any changing needs of the resident. Such care and services shall be detailed in the ICP. 1. The facility shall render care and services in accordance with orders from physicians or other authorized healthcare providers and take precautions for residents with special conditions, e.g., pacemakers, wheelchairs, dementia, etc. The facility shall assist in activities of daily living as needed and appropriate. Each facility is required to provide only those activities of daily living and only to the levels specifically designated in the written agreement between the resident and or her responsible party/guardian and the facility. 1. The facility shall provide necessary items and assistance, if needed, for residents to maintain their personal cleanliness, e.g., soap. 2. The provision of care/services to residents shall be guided by the recognition of and respect for cultural differences to assure reasonable accommodations shall be made for residents with regard to differences, such as, but not limited to, religious practice and dietary preferences. The facility shall make opportunities for participation in religious services available. Reasonable assistance in obtaining pastoral counseling shall be provided by the facility upon request by the resident. In the event of closure of a facility for any reason, the facility shall ensure continuity of care/services by promptly notifying the resident's attending physician or other authorized healthcare provider and responsible party, and arranging for referral to other facilities at the direction of the physician or other authorized healthcare provider. 2. Fiscal management. 2. Provisions shall be made for safeguarding money and valuables for those residents who request this assistance. Residents shall manage their own funds whenever possible. Only residents may endorse checks made payable to them unless a legally constituted authority has been authorized to endorse their checks. In situations where a resident becomes unable to manage his/her funds, the administrator shall contact a family member or the county probate court regarding the need for a court-appointed guardian or conservator. The licensee, administrator, sponsor, or any of their relatives shall not be appointed guardian or conservator. Upon written request of the resident, the administrator may maintain the personal monies for the resident. The licensee may be designated payee for a resident. There shall be an accurate accounting of residents' personal monies and written evidence of purchases by the facility on behalf of the residents to include a record of items/services purchased, written authorization from residents of each item/service purchased, and an accounting of all monies paid to the facility for care and services. Personal monies include all monies, including family donations. No personal monies shall be given to anyone, including family members, without written consent of the resident. If a resident's money is given to anyone by the facility, a receipt shall be obtained. A report of the balance of resident finances shall be physically provided to each resident by the facility on a quarterly basis in accordance with the resident's Bill of Rights, regardless of the balance amount, e.g., zero balance. Documentation of quarterly reports to residents shall be readily available for review. Recreation. The facility shall offer a variety of recreational programs to suit the interests and physical/cognitive capabilities of the residents that choose to participate. The facility shall provide recreational activities that provide stimulation, promote or enhance physical, mental, and/or emotional health, are age-appropriate, and are based on input from the residents and/or responsible party, as well as information obtained in the initial assessment. There shall be at least one different structured recreational activity provided daily each week that shall accommodate residents' needs/interests/capabilities as indicated in the ICPs. The facility shall designate a staff member responsible for the development of the recreational program, to include responsibility for obtaining and maintaining recreational supplies. At least one staff person shall be responsible for providing/coordinating recreational activities for the residents. The recreational supplies shall be adequate and shall be sufficient to accomplish the activities planned. A current month's schedule shall be posted in order for residents to be made aware of activities offered. This schedule shall include activities, dates, times, and locations. Residents may choose activities and schedules consistent with their interests and physical, mental, and psychosocial well-being. If a resident has dementia and is unable to choose for himself/herself, staff members/volunteers shall encourage participation and assist when deemed necessary. Transportation. 1. The facility shall secure or provide transportation for residents when a physician's services are needed. Local, as defined by the facility, transportation for medical reasons shall be provided by the facility at no additional charge to the resident. If a physician's services are not immediately available and the resident's condition requires immediate medical attention, the facility shall provide or secure transportation for the resident to the appropriate health care provider such as, but not limited to, physicians, dentists, physical therapists, or for treatment at renal dialysis facilities. Safety precautions/restraints. 1. Periodic or continuous mechanical, physical, or chemical restraints during routine care of a resident shall not be used, nor shall residents be restrained for staff convenience or as a substitute for care/services. However, in cases of extreme emergencies when a resident is a danger to him/herself or others, mechanical and/or physical restraints may be used as ordered by a physician or other authorized healthcare provider, and until appropriate medical care can be secured. Exception. Antipsychotic medication administered to residents with Alzheimer's disease or dementia is not considered a chemical restraint if the resident has been prescribed the antipsychotic medication in a physician order and/or PRN and the resident only receives the prescribed dosage of medication as indicated on the physician order and/or PRN, and every medication administration is recorded pursuant to the requirements of this regulation. Only those devices specifically designed as restraints may be used. Makeshift restraints shall not be used under any circumstance. Emergency restraint orders shall specify the reason for the use of the restraint, the type of restraint to be used, the maximum time the restraint may be used, and instructions for observing the resident while restrained, if different from the facility's written procedures. Residents certified by a physician or other authorized healthcare provider as requiring restraint for more than 24 hours shall be transferred to an appropriate facility. During emergency restraint, residents shall be monitored at least every 15 minutes and provided with an opportunity for motion and exercise at least every 30 minutes. Prescribed medications and treatments shall be administered as ordered, and residents shall be offered nourishment and fluids and given bathroom privileges. Discharge/transfer. Residents shall be transferred or discharged only as appropriate per the provisions of the Residents' Bill of Rights. In cases of medical emergencies, immediate transfer is permissible. However, the family member and the sponsor, if any, shall be notified at the earliest practical hour, but not later than 24 hours following the transfer. 2. Prior to discharge, the resident, his/her appropriate family member, and the sponsor, if any, shall be consulted. Residents shall be transferred or discharged to a location appropriate to the resident's needs and abilities. Residents requiring care and/or supervision shall not be transferred/discharged to a location that is not licensed to provide that care. 2. Upon transfer/discharge of a resident, resident information shall be released in a manner that promotes continuity in the care that serves the best interest of the resident. Upon transfer/discharge, the facility shall ensure that medications, as appropriate, personal possessions and funds are released to the resident and/or the receiving facility in a manner that ensures continuity of care/services and maximum convenience of the resident. Section 1000. Rights and Assurances. 1001. General. 2. A. The facility shall comply with all current federal, state, and local laws and regulations concerning resident care, resident rights and protections, and privacy and disclosure requirements, e.g., 1976 Section 44-81-10, ETC, Residents' Bill of Rights, Alzheimer's Special Care Disclosure Act, and the Omnibus Adult Protection Act Notice, 1976 Code Section 43-35-5, ETC. 1. The Residents' Bill of Rights, the Omnibus Adult Protection Act, and other notices as required by law, shall be prominently displayed in public areas of the facility. The facility shall comply with all relevant federal, state, and local laws and regulations concerning discrimination, e.g., Title VII, Section 601 of the Civil Rights Act of 1964, and ensure that there is no discrimination with regard to source of payment in the recruitment, location of resident, acceptance, or provision of goods and services to residents or potential residents, provided that payment offered is not less than the cost of providing services. Achieving the highest level of self-care and independence by residents shall be reflected in the manner in which the facility provides/promotes resident care, e.g., residents making their own decisions, selecting a physician or other provider, maintaining personal property, managing finances. Should a facility develop house rules, the rules shall not be in conflict with the provisions of the Residents' Bill of Rights or other rights/assurances addressed in this regulation. Residents shall be provided the opportunity to provide input into changes in facility operational policies, procedures, services, including house rules. Residents shall be assured freedom of movement. Residents shall not be locked in or out of their rooms or any common usage areas, e.g., dining, sitting, activity rooms, in the facility or in or out of the facility building. Exit doors may be equipped with delayed egress locks as permitted by the codes referenced in Section 1902, A1. Exception. Exit doors may be locked with written approval by the department and as permitted by the codes referenced in Section 1902. The facility shall develop a grievance/complaint procedure to be exercised on behalf of the residents to enforce the Residents' Bill of Rights, which includes the address and phone number of the department, and a provision prohibiting retaliation should the grievance right be exercised. Care, services, and items provided by the facility, the charges, and those services that are the responsibilities of the resident shall be delineated in writing. The resident shall be made aware of such charges/services and changes to charges/services as verified by the signature of the resident or responsible party. Residents shall not be requested or required to perform any type of care/service in the facility that would normally be the duty of a staff member/volunteer. Residents may be allowed to engage in such activities as listed in the ICP with written authorization, not necessarily in the ICP from a physician or other authorized healthcare provider, if strictly voluntary and under proper supervision. 1. Residents shall be allowed sufficient time to attempt and complete activities of daily living tasks without unnecessary intervening by staff members/volunteers in order to expedite completion of the tasks. Staff members/volunteers shall intervene appropriately as necessary to assist residents whose completion of the tasks may be impeded by their physical/mental condition. Residents shall be permitted to use the telephone and shall be allowed privacy when placing or receiving telephone calls. This access shall include business hours from 7 a.m. through 8 p.m., 7 days a week, and other times when appropriate. This telephone service shall be available for use by residents and or visitors for their private, discretionary use. Pay phones for this purpose are acceptable. Telephones capable of only local calls are acceptable for this purpose, provided other arrangements exist to provide resident/visitor discretionary access to a telephone capable of long-distance service. In instances when a resident moves/relocates, lack of advance notice by the resident of the departure shall not relieve the facility of the obligation to refund the monies due the resident. The facility may charge the resident no more than 14 days of occupancy if the resident fails to notify the administrator in writing of the intent to voluntarily relocate. However, if the facility is able to fill the bed vacated by the resident, the facility shall cease charging the resident regardless of the notice given. The facility shall notify the previous resident in writing as soon as it fills the bed with a new resident. This does not apply to residents that participate in the Optional State Supplementation Program, OSS. Voluntary relocation does not occur when a resident of a CRCF seeks to be discharged because a higher level of care is required or because the resident's health, safety, or welfare is endangered. Section 1100. Resident Physical Examination and TB Screening. 1101. General. 1. A physical examination shall be completed for residents within 30 days prior to admission and at least annually thereafter. Physical examinations conducted within 30 days prior to admission by physicians licensed in states other than South Carolina are permitted for new admissions under the condition that residents obtain an attending physician licensed in South Carolina within 30 days of admission to the facility and undergo a second physical examination by that physician within 30 days of admission to the facility. The physical examination shall be updated to include new medical information if the resident's condition has changed since the last physical examination was completed. The physical examination shall address The appropriateness of placement in a CRCF. Medications/treatments ordered. Self-administration status. Identification of special conditions/care required, e.g., a communicable disease, dental problems, podiatric problems, Alzheimer's disease and/or related dementia, etc., and the need of, or lack thereof, for the continuous daily attention of a licensed nurse. The admission physical examination shall include a two-step tuberculin skin test, as described in Section 1702, unless there is a documented previous positive reaction. The physical examination shall be performed only by a physician or other authorized healthcare provider. If a resident or potential resident has a communicable disease, the administrator shall seek advice from a physician or other authorized healthcare provider in order to ensure the facility has the capability to provide adequate care and prevent the spread of that condition, and that the staff members/volunteers are adequately trained. Transfer the resident to an appropriate facility, if necessary. A discharge summary from a healthcare facility, which includes a physical examination, may be acceptable as the admission physical examination, provided the summary includes the requirements of Sections 1101, AC above. Isolation provisions. Residents with contagious pulmonary tuberculosis shall be separated, see Section 1702(e), from all other non-infected residents until declared non-contagious by a physician or other authorized healthcare provider. Should it be determined that the facility cannot care for the resident to the degree which assures the health and safety of the resident and the other residents of the facility, the resident shall be relocated to a facility that can meet his/her needs. In the event that a resident transfers from a facility licensed by the department to a CRCF, an additional admission physical examination shall not be required, provided the sending facility has had a physical examination conducted on the resident not earlier than 12 months prior to the admission of the resident to the CRCF, and the physical examination meets requirements specified in Sections 1101(a), see above, unless the receiving facility has an indication that the health status of the resident has changed significantly. A tuberculin skin test and/or BAMT shall be required within 1 month after admission to the CRCF to which the resident transfers to document baseline status for that facility.